Now, I'd like to thank you for coming before us today, as I said at the outset, and in sense of fairness, to give a response to the evidence that we heard on Wednesday. Just as regards the submission, I just want to say that possibly it would have been of assistance to us if your submission had been given to the members in advance of the meeting. But that's just a by the way. If I might, just before I hand over to Deputy Dooley, ask you a couple of questions in relation to, I think, page 5 of your submission. You say that in any public consultation process under legislation, it is the actual content of the submissions made that is considered by the decision maker in helping to reach a decision. Does that relate to even fraudulent submissions? In other words, is it the content of a fraudulent submission that will be taken into account, or does it not matter then whether it's fraudulent or genuine? Secondly, just to clarify a couple of events that have happened since you were in since Tuesday. It was reported, read it in media outlets, that the effort to have an uncontested judicial review, which you stated in fairness here on Tuesday that you would contest, or the Dublin City Council would contest, was it? It was suggested that if it weren't to be contested, that it would be a resigning matter for you. Was that information correct? That was in the media. And third question to Mr. Keogan. You stated here on Jim on Tuesday that you had a property in the vicinity of Croke Park that your son is living in now, and that he didn't make a submission. Have you any other interests or property in the vicinity, or did any other relations of yours make a submission in relation to the concerts? Thank you.
Just in relation to the last point, no, I don't have any other property interests in the area, and to my knowledge, I'm not aware of any person that would be related to me made a submission, to my knowledge, and that's been as long as I possibly can on the matter.
I just wanted to clear that up. That's fine.
Okay. Just in relation to the first matter that you raised, which is do we take into account the content of a fraudulent submission? I think the point that we're making here is that it's not necessarily the volume of submissions, it's the actual issue that's raised in the evaluation assessment of a particular proposal. So consequently, if it's 1, 15 or 500, that's not the issue. It's whether or not the content of what's being raised is or is not material to the assessment. When we made the decision, we were aware that there was 12 fraudulent or suspect submissions, and we alerted the Gardaí. It's transpired that there's evidence to suggest of the investigation that has been carried out to date, 64% of those investigated would appear not to be in any way bogus or legitimate. The opinion of the law agent sought thereafter was that the decision is sound, and the integrity of that decision is also sound, and there has been no challenge to that decision as yet in the context of say as to whether or not we erred in law in relation to making that decision.
Just in relation to the prospect of an uncontested judicial review, Chairman, my understanding is that the purpose of the judicial review is to examine if the correct procedure has been applied in any administrative process. I stand absolutely firm in my belief that while the decision that was made may well have been unpopular, that the event licensing process, the statutory event licensing process, was correctly applied in this case by Dublin City Council. And that's a process laid down by the Oireachtas. And on that basis, for me to have engaged or consented to an uncontested judicial review would have been an acknowledgement that it hadn't been. So it would be completely contrary to everything I've said to this committee and every belief I had in relation to that process. So I would lose all credibility if, having stated here, and that we had applied that process correctly, if I then consented to an uncontested judicial review.
So it would have been a resigning matter in that case?
I would have resigned.
And just one final question before I hand over. I think, I'm not sure which of you stated here on Tuesday that usually there'd be 10 or 20 submissions or objections, and that there was 384 in this case, I think, was it? Did that at any stage kind of hint to you that there may be fraudulent objections?
No, the regulations state that any person, and it doesn't necessarily have to be a person that's living or residing in the immediate area of Croke Park, can make a submission or observation on a particular event licence application. Certainly we would have been, it was a matter, that we discussed that there was a significant volume of submissions. We were very aware of the fact that there was quite a lot of controversy in the area, and there had been numerous public meetings related to the proposed event in question. But go back to the issue of what the regulations state. The regulations are silent in relation to what you do with the submission. There's no requirement to acknowledge, but it is custom and practice of the City Council as a licensing authority that in respect of all submissions and observations we actually give an acknowledgement, even though we're not required under regulation. On foot of that process, and again it's not required under the regulations, it was drawn to our attention that there was an issue relating to 11, and on foot of that we drew it to the attention of the Gardaí. So as I said, we did everything in our power to kind of ensure that the system was upheld to a proper legal process.
Okay, Deputy Dooley.
Thank you very much. Just to welcome Mr. Owen Keegan and Downey again, and thank you for being with us. Just going through the evidence that you've given us again, certainly from my point, I don't question in any shape or form the way in which the event licence procedure was applied. I don't think there's anybody in this House that has any issue with the way in which you've followed procedure. I think you've followed it in the way that it should be followed. My issue, and I think the issue of most people, is with the outcome, the decision that you ultimately took. So whilst we might raise questions about the decision arrived at, it's not to in any way suggest that we believe that you followed the wrong procedure or you did something necessarily wrong in that effort. But that's the statutory period from the time when the application was lodged to the decision was taken. Now, just in general interaction with yourselves, the GA, or between yourselves, the GA and Aikens, I suppose it's why we're here today, because of the issue that arose by virtue of what both Mr. McKenna and Mr. Duffy said here, that there was a belief, based on that conversation back in February, that Dublin City Council would support a licence application for all 5 concerts. Now, in fairness, Mr. Keegan, you haven't denied that you gave that impression to Mr. McKenna. What you have said in a statement that you issued, you said you gave no assurance. You went on to look at what Aiken had said, and you said there was no certainty, there was no firm offer. These are all absolutes. Mr. McKenna has never indicated that there was an absolute, because he couldn't until you'd entered the statutory process. They may not have been able to reach a particular, may not have been able to solve a particular problem if such arose as part of the process. But if you then look at the decision that you took and the reasons that you took it on, it was based on intensification. It would have been setting a new precedent, which you felt would have led to an unacceptable level of disruption. Well, it would seem to me that those were all issues that were blindingly obvious to you back in February, when you gave that, or had that conversation with Mr. McKenna, where you gave the impression that you'd be supportive in a general way, without the issue of assurances. We all accept that. We know how the process works. You couldn't have, you wouldn't have the authority to do it at that stage. But you gave him some belief, he had some expectation, legitimate or otherwise, that if he submitted an application for 5 concerts, and recognising that additionality would be required, And if they had reached that threshold, then they could legitimately expect a positive outcome. But it seems to me, as I said, and I'm maybe repeating myself here, the issues which you refused the five licenses on were all blindingly obvious, it seems now, to you in advance of that process even beginning. So the question is, why did you lead Mr. McKenna to believe that you would be supportive, albeit in principle, of 5 licenses? That's the first question, so maybe you can address that first.
Well, I'm glad we cleared up any misunderstanding, and I fully accept that I did indicate that I would support the 5. And I suppose looked at from my perspective, I mean, you know, given the economic value of this to the city, if I had either refused to take a phone call or said, we're totally opposed to this, right? You will never get a license. I would have been accused of, you know, undermining a major event coming to the city. So I would always work on the basis that, in a positive way, to try and encourage people. But I would have made it clear to them, you know, that the key issue was, there were 2 issues, as I would have seen it. One, to make sure there were no issues emerging from the One Direction concerts. And the second crucial issue would have been to deal with the legitimate concerns of the residents. And it would be my view that what subsequently emerged through the licensing period, that there was a failure to deal with the legitimate concerns. And if you don't agree with my view on that, I've given you the view of the Director General, who has publicly said that it was too big an ask. So clearly there's a recognition by the GA that there were legitimate concerns and that having 8 concerts was too big an ask. And it's interesting that Mr. Mulvey had recommended that there should be a maximum of 3. So it's not the City Council. The City Council has gone way beyond Mr. Mulvey's recommendation in permitting 3 concerts on top of the 3 that already took place. So I suppose I wouldn't have liked to rule out the possibility of this, and I would have believed myself that if the legitimate concerns of the residents had been taking place, it would have been possible to give a licence. And I would just point to the fact, you know, I mentioned to the committee at the last session, I was very familiar with the application of the event licensing process in respect of Marley concerts. And in my understanding, in the 14 years there have been concerts at Marley, the total number of objections received was 1. So it is possible, you know, there are all kinds of issues associated with concerts, no matter what the location is in terms of the impact of local residents, but with proper management and engagement, it is possible to address those concerns. There was a single failure to do it in respect of this particular case, and that became evident during the licensing process.
So, just then to be clear, Mr. Kennedy, you have indicated that the conversation with Peter McKenna did contain an expression by yourself that you were supportive of 5 concerts. That's what you've said to us.
Yeah, I would have been supportive at that stage of 5 concerts, yes.
So then, how was it at that stage that you didn't envisage that it was a breach of precedent, which you said was one of your decisions for refusal? You were aware that 3 One Direction concerts had taken place. You were aware of the planning law in relation to the fact that they were allowed 3, and that 3 events had already taken place for the year. So that the precedent issue, you should have been aware of it. You should have certainly been aware that it constituted an over-intensification, if that was what the ultimate outcome was, and it seems to be the reason why you did it. Now, the level of disruption is probably the only one that you might have some grounds to say that, well, they didn't succeed in providing the appropriate plan that could have mitigated the worst effects of the over-disruption. But the other 2 seem to me that they should have been blindingly obvious to you, that 5 concerts represented over-intensification, if it did, and that it was a breach of precedent. So those are 2 reasons that you gave, or that Mr. Keogan arrived at in the process of the statutory procedure, that were grounds for refusal. But yet you didn't see those back in February, nor did you see them for the following number of months when the 10% of the country were excited, exhilarated, whatever, about attending this event. It became a major national event, to quote Pádraig Duffy. Tickets were being sold, stages were being built, lighting rigs were being put together, and packed onto a boat somewhere in the United States to come here, and all the while you sat back, believed everything was okay, and allowed this to spiral out of control. It's a hard one for me to fathom. It's a hard one for your ratepayers to fathom, and I note that the Restaurant Association have issued a statement today, very not personalised towards you, Mr. Keegan, in fairness. It's very negative towards Dublin City Council. They've passed some kind of a motion that demonstrates that they lack confidence in Dublin City Council to be pro-business. That's a damning indictment of the executive within Dublin City Council, I would have thought, and one which I would expect you'll need to respond to. These are your ratepayers at the end of the day. These are the people who are most affected by the cancellation of all the events now. They're the people who have the most to lose, and the people who they employ have the most to lose. So I'm just not comfortable that you were able to be seen to be supportive back in February, and you reach a decision which prevents the concerts going ahead, and two of the reasons that you outline as being part of your decision to refuse should have been blindingly obvious to you right from the very start.
Just in response to the issue of intensification, I think it's fair to say, and I think everybody accepts like that from day one when we were made aware of the number of concerts being proposed, that we always said that the issue of its impact on the surrounding neighbourhood would be central to any assessment and subsequent decision on the licensing process. And that was consistent from day one. We were in a situation where tickets had been sold. We had been notified but not consulted, and I referred to that the last day. The desirability of having a formal pre-application consultation where frankness could prevail, as distinct from a situation where there was a liability of court proceedings arising from, say, what you might say or what didn't say. Just on the intensification, you've raised it, and I noted from Pádraig Duffy's comments yesterday that he was suggesting that we may in some way be trying to curtail the amount of sporting events that would take place in Croke Park in the future. That's not the intention. Dublin City Council and the Planning Authority have no issue with the number and intensity of sporting events in Croke Park. That's the established use, the approved use. Others may have difficulties with that, but the Planning Authority has no issue with it. The profile of the sporting events is that given, and it's only really arisen since the restructuring of the championship campaign, is that you may have not more than 2 consecutive days where you'd have a sporting event. And it's only on the advent of, say, the playoffs that you would have Saturday and Sunday. So that's 2 consecutive days for a sporting event. The issue is concerts, and it's a very different type of use. And if you look at it, it's a different type of crowd. It's certainly a different time frame. They're much later, with a later closing time. It's a festival, they're more boisterous, and there's a noise associated with them. And while sporting is not an issue, and we welcome the opportunity that they may get in the future to have the Rugby World Cup or any kind of major European championships there, that's not going to be an issue for the Planning Authority. The issue is concerts, and the profile of those concerts, and it's the cumulative effect of 5 nights of consecutive concerts on an area. We felt, and we were conscious of, the widespread economic benefits accruing to this, that there had to be a reasonable, balanced and fair approach to the licence applications, and we struck on 3. And that was the basis of...
If I could question a little bit on that, to talk about the profile of the concerts, then do you give any consideration to the artist concerned? You weren't talking about Metallica here. It wasn't going to be a massive rave. I think anybody that looked at the profile of the people who purchased tickets, I think you could fairly assume that it wasn't going to be a drunken bash in Croke Park for 5 nights. Issues that had arisen in relation to other events in the Phoenix Park in the past, created great concern, and I'm sure it created and posed challenges for you and how you'd manage those again. So what you're saying is that the profile of the event, which would detail or would take into consideration the artists, the kind of followers, the fans, all of that, is that what we're talking about with the profile here?
What I'm trying to get across here is that the issue is intensification. And what I'm saying to you is like that there's a very different kind of impact arising from, say, a sporting occasion, which is the established use of the stadium, and nobody has an issue with it.
But would you accept that there's a very different intensification from, depending on who the entertainer is?
Well, the regulations don't stipulate that we would distinguish between the type of artist. That would be a profiling that the Gardaí would carry out as regards public order.
Regulations require you to take a different approach based on the profile of sport versus entertainment.
No, the regulations require you to have regard to public order.
Yeah.
And the Gardaí would be profiling the nature of the possible attendees at such an event, and they would put in the appropriate measures to safeguard it. I'm just saying that it's a very different type of use. You know, the use of it for sporting purposes as distinct from concerts, it has a different impact, and the accumulative effect, I go back to the accumulative effect of 5 nights in succession up until, say, 11 o'clock. And you know yourself, on All Ireland Day, you'd have 82,000 people coming out of there come 6 o'clock. It's very silent, it's very quiet, but that would extend into, say, 12 o'clock, 1 o'clock in the morning in the surrounding immediate areas. And that's the impression, and that's the factors that we took into account, and that's where the intensification comes in.
Did you want to address anything?
I accept that the issues of intensification and the precedent, but we have demonstrated in the decision, we have already permitted an increased intensification by allowing 3 concerts. So in total this year there are 6 concert special events. The highest in any previous year was 4, so we've already allowed for that. And we've already broken a precedent because the highest number in any previous occasion was 4, we've given 6. So I think we demonstrated that there would have been scope. And I suspect that if the issues of this legitimate concerns of residents had been properly addressed, there would have been scope for further intensification and a further greater breach with precedent.
How could they have been properly addressed, in your opinion?
Well, it's a matter for the GA and the event promoter. But the reality was, right, as I said, I'm familiar with other concert venues where almost there are no objections. A significant number of objections. Whether that number was, maybe the number legitimate was only 250. Let's say it was about that. That's a very significant number of objections. I'm aware that there were public meetings in which there was major outcry about this. And no less a figure than the Director General himself has said in public that 5 was too big an imposition on the local residents. So there was clearly a failure. It's a matter for the applicant to undertake the necessary work, not for the licensing authority.
And I think that was just to put that in context, we don't want to have another session here next week where we have to bring Pádraig Duffy back again, but I think, if I recall, his comments on the television was in the context of the Mulvey proposals and an effort made to try and mitigate the concerns. So I think the opening statement was it was too big of an ask, so therefore something more had to be done. And I think that's where everybody accepted. I mean, you talked about what discussions with Aiken. You said it was a big ask, but the big ask was somewhat clouded or cotton-wooled in the follow-on statement, which said additionality will play a role. So in other words, you have to do more than you might normally do. So that, in my view, gave an expectation that this could be resolved, that 5 licenses could issue. And I think that's why we're in the mess that we're in. And it seems to me, and I go back to the point, you've made your comments on it, that over-intensification and precedent, which are the 2 big issues, should have been identified at the outset, and we mightn't be where we are. But
Okay, do you want?